Good evening, everyone. Welcome to another episode of Confabulating. It is our pleasure to be joined this evening by Professor Fernanda Pirie of St. Cross College, Oxford, who will be speaking tonight on how humans use law to shape civilization. Fernanda specializes in the anthropology of law and is a director of graduate studies for social legal studies at St. Cross College. She holds a DPhil in social anthropology from Oxford and an MSc in the same field from UCL, and formerly practiced as a barrister for 10 years. Her latest book, The Rule of Laws, a 4,000-year quest to order the world, was published in 2021 and is a global history of law. It traces the rise and fall of the world's major legal systems and compares examples of historic lawmaking worldwide. Her other works focus on the nature of law as a social form and its role in societies, turning to history in the anthropology of law, law and Buddhism in pre-modern Tibet, and the ideas of community and justice, to name a few. She's also worked on the projects Legal Identity in Tibet, Politics, Practice and Religion, an AHRC-funded project on the legal history of medieval Tibet from the 10th to the 17th centuries, which has led to a series of publications and a website with source material, that being www.tibetanlaw.org. Her research uses anthropological and comparative methods to compare legal practices and texts from around the world, and she has carried out ethnographic fieldwork at both ends of the Tibetan plateau and conducted historical work on Tibetan legal texts. Her key research interests include the anthropology of law, Tibetan law and legal practices, global legal history, and the English bar. Fernanda, we are delighted to have you with us this evening. Thank you so much for joining us.
Well, thank you very much for the invitation.
Not at all.
So, would you like me to get stuck in with what I have to say about how humans use laws to shape societies?
Absolutely, please do.
Yeah, great. Well, as you say, I'm an anthropologist. Even though I work in the law faculty in Oxford, I'm an anthropologist. So I started off my anthropological career looking at a very typical anthropological topic, which was conflict resolution in contemporary Tibetan societies. And that went from Ladakh in the west of Tibet, where in India, where I spent a year living in a rather remote village, looking at how they resolve all the disputes, and then further field work in the east in what is now China, where I was living with nomads for about the same sort of period of time, and contrasting the way they resolve their disputes. So, but while I was there in eastern Tibet among the nomads, I discovered some legal texts, which were rather interesting because these were nomads, they weren't centralized, they didn't have any sort of central authority. So what were they doing with these legal texts? They didn't really seem to apply them either. They seemed to mediate all their disputes. But these texts were clearly important. They referred to them. They showed them to me. So that got me thinking about, well, who makes law and who doesn't? The Ladakis in the West seemed to do perfectly well without any law. They never wrote anything down. They didn't have a village constitution. They didn't record their disputes. They remembered everything. They had a strong sense of custom, but nothing that they sort of wrote down in legal form. Well, here these nomads in the East, also decentralized society, were actually writing down their text. And the contrast made me think, well, some societies use laws, write things down, and some of them don't. So what's this all about? And so then that led on to a more sort of collaborative project with colleagues here in Oxford and ultimately elsewhere, looking at just examples of people using law for very different things all around the world, both in the contemporary period and back into history. So we got into historians and classicists and area studies people and some lawyers as well, with interesting examples of often sort of small scale societies where people use laws or didn't use laws in all sorts of different forms. And these are sometimes religious context, sometimes village community, sometimes tribal, sometimes people making laws in the shadow of one of the great legal systems, one of the Islamic legal systems, or in China, or the India Dharma Shastra tradition. And so that led to lots of discussion about what law is and what it does. And ultimately, I felt that this really deserved a book, and it might be something that the general public would be interested in. So there I had a sort of sense of where I wanted to get to, but what was I going to put in it, and how was I the story I was going to tell? So ultimately, I came up with, I don't know, does this come out the right way on the screen, or did it come out back to front anyway?
Yeah, that's absolutely perfect.
which is it's better, as you said, essentially a global history of law. And I start off with, okay, let's start at the beginning in good sort of, historical fashion. So I start off with the earliest known laws from anywhere in the world, Mesopotamia, about 4,000 years ago, in fact, sort of 2,200 BC. And then I go through the legal tradition in China, in India, in Rome, the Islamic world, eventually medieval Europe. And then in the middle part of the book, I look at lots of more detailed evidence from sort of roughly the Middle Ages and much more localized context. And then finally, the last part of the book come up to the present day. So maybe in the next sort of 20 minutes or so, I might just give you a bit of a sense of some of the big themes that emerged when writing the book, and some of the sort of the standout moments and events that sort of punctuated human history in terms of writing laws. So I think that some of the earliest examples in Mesopotamia are some of the most interesting, because about the 3rd millennium BC, the 2500s-ish BC, we have the first archaeological evidence of city-states, centralized governments of some sort, temples, lots of mercantile relationships, irrigation. So this is all the Fertile Crescent in Mesopotamia, in what's largely now Iraq. And at some point, they basically invented writing, cuneiform writing, where they're using those little styluses to make marks on clay tablets, which then get fired. And dry climate, of course, dozens, thousands of these have remained, which is fantastic for archaeologists. And some of the earliest inscriptions where they actually record speech are invocations to the gods. And some of these are by the rulers. So this was an era in which warlords were regularly going out, sacking each other's cities, trying to take over their lands, enslaving their populations, often actually putting fire to their cities. But what some of these inscriptions record is promises by these warlords. They've taken over a new city and they're making promises to the people. Look, we've got rid of their old rulers. They were oppressive. We know that. They were taxing you too much. Trust us to make life better. They were making promises to the people they just conquered, because clearly they wanted to get their loyalty, or else they were never going to be able to keep control of their cities. And in among these promises about what they would do were essentially promises that they had the favor of the gods and that they would mete out justice. So this is where we find the first laws, basically just saying, this is how you, the citizens, will get justice under me. If somebody steals from you, they will be punished. If somebody injures you, you will get compensation. If you have a dispute about marriage, this is how it will be solved. Commercial disputes will be solved. They're fairly basic, but essentially they're promising justice to the people. But, we think about nowadays about laws as being about regulating society, telling us what we've got to do, coordinating complex societies and so on. But these very earliest laws, they were really about promising justice to people by the rulers who wanted to present themselves as divinely blessed and as capable of bringing peace, prosperity, and justice to their people. And that goes for the most famous of these sets of laws, which I don't know if you've ever seen it in the Louvre Museum in Paris. There's a whole room with artifacts from ancient Mesopotamia. And there's this huge granite statue. It's really impressive. The big picture at the top of the warlord called Hammurabi, who was very successful, basically conquered the whole of Mesopotamia in about 1700 BC. And he made this big law stone, which is covered with cuneiform writing and covered with laws, about 300 of them. And there are lots and lots of examples. He clearly sent them all the way around his kingdom. I mean, huge expense, getting these granite stones made and carved up and carted around the place, clearly demonstrating his stature as a king. So these are the first laws, basically promising people. And some of the archaeologists tell us that, well, it was actually an issue for these warlords to secure the loyalty of the people, particularly the nomads. Nomads were out there controlling the trade routes, supplying animals and meat products, and they could easily run away if they didn't like their rulers. So promising justice is really important to get their loyalty. And then these laws have this long afterlife. So 1,000 years later, you find the earliest laws being made among the Israelites, the earliest iterations of the Old Testament laws. And there's clearly a continuity between these two things over such a long period. So if I can just sort of briefly go to the lands of Israel and Judah. Now, I mean, there's masses and masses of scholarship on the Old Testament, where it came from, who wrote it, and lots of it is completely unknown. There's lots of guesswork about it. However, we do know some things about the context in which it was made. And essentially, the Israelite tribes clearly had their traditions. And some of the laws that were eventually written down talk about obvious things like agricultural matters, animals who go wild, family relations, theft, injuries, all that sort of thing. And there are some rules which probably reflect, the time of the kings. In about 1000 BC, they have the first kings in the Israelites' land. And then there are more commercial relations, debt bondage, slavery, and so on. But the biblical scholars tell us that the time that these laws were probably first collated and written down in the form they now have in the book of Exodus in the Old Testament was probably not till sort of the middle of the first millennium BC, after their lands had been overrun by the Assyrians and the Babylonians, and their cities had been destroyed, and the Israelite people were in danger of dispersing, essentially, back to their tribes, back to their lands, among all the other people they lived among. And it was the priests who really wanted to hold them together as a single people, to reaffirm their identity as Israelites, as worshipping one God. And it was the priests who really put together the Pentateuch, the first 5 books of the Bible, in attempt just to confirm, this is who we are. This is where we come from. These are the rules we follow. So endless rules in the Pentateuch about ritual and sacrifice and creating the ark and what to wear and what to eat. And again, as well as history of the Israelite people and where they've come from and that sort of thing. And so the laws were collated and written down as part of this big project, this priestly project, essentially, to keep the Israelites together as a people, to give them identity. Fantastically successful. There they are, 3,000 years later as very distinct people. But the scribes who actually wrote down the laws clearly copied the Mesopotamian tradition that went back 1,000 years to Hammurabi. It's clear from the form of the laws, the same type of form. And so historians think there was essentially a whole tradition of scribes and scribal schools in that region in the Middle East, which lasted from Hammurabi's time through to the sort of 5th or 6th century BC. And so the Israelite scribes were basically using the same tradition, copying the laws, some of the laws very similar. So eye for eye, tooth for tooth, etc. Both Hammurabi's laws and the laws of the Old Testament. So here, very similar sorts of laws, but being made by very different people in very different circumstances. There's Hammurabi, the successful warlord trying to get the loyalty of his people, to gather them together as citizens. And over 1,000 years later, it's a set of priests who are trying to hold together this dispersed people who've just been conquered with very much religious purposes, telling them they're all worshipping one God, holding them together as a people. So just at the very dawn of the laws, we get these very different purposes for which people use laws. So how are we doing for time? Yeah, so let me just hop around a little bit. China, India, Rome, all just wonderful contrast. So while all this is going on, Chinese civilization is getting going, again, turbulent periods in sort of the first millennium BC. And the first laws are made a little bit like in Mesopotamia, essentially by warlords who are trying to establish their own kingdoms. But instead of promising justice to the people, under the influence of the legalists, Lord Shang, the arch legalists, they decide that what they need is a set of punitive laws. They need to discipline their people. They need to tell them clearly what's right and what's wrong, punishments and rewards. So the very first laws in China is just lists of punishments, and probably sent out to all their officials and said, right, this is what you've got to do. And that set the tone for basically the Chinese imperial laws for the next 2,000 years. They're all punitive in form. And of course, they go through lots of iterations, the different dynasties. The earliest really long sets of laws made by the Qin at about 200 odd BC. And then they're followed by the Han, who sort of copy the laws and elaborate them a little bit. And then the Tang in the 6th or 9th centuries make an even more elaborate code. So the codes get more and more elaborate as the Chinese empires get bigger and the emperors get stronger. And they cover all sorts of administrative matters and also sort of relations between ordinary people, family relations, taxation, commercial disputes, thefts and injuries, the basic sort of thing. But everything is punitive. It's all about crime and punishment, which makes the Chinese laws really very distinctive. So if you could say that Hammurabi was promising justice to his people, the Israelite priests were offering rules that would hold their dispersed people together. But the Chinese was all about discipline. It's all criminal law. So that's China. Very brief insight into what's going on in China. In the middle of all this, and in between those two, there's India. India, again, a priestly tradition, which leads to the lawmaking. And these are the Brahmins. These are the ritual specialists. So the Aryans have come into India, and come to northern India, sort of the Ganges region, probably coming down from Central Asia in the 2nd millennium BC. Lots of debates about where the Aryans have actually come from. They sweep into northern India. Again, they're quite a warlike people, but very early records tell us that the local warlords, the local kings leading their armies into battle have priests with them. So there's a separate set of priests, very important, and they ride into battle with the warlords to keep them safe, to say the mantras, to perform the rituals that keep the king safe in battle. So this group of priests, they band together, they form hereditary classes, and they form their own. They formulate their own specialist knowledge about the rituals, the invocations to the gods, the things that will keep the kings and the people safe. And gradually they become more and more learned and more esoteric and start writing down their invocations, their rituals. And these become the Brahmins. They are the ancestors of the Brahmins who are now everywhere in India and beyond. And so eventually they are the ones who, they're the keepers of literacy. They write all sorts of ritual texts, and they start writing texts about the arts of government, telling the kings how they ought to govern, and eventually sets of laws for ordinary people, for everyone, telling people how to live their daily lives. So these are the Dharma Shastras. These are the laws which really form the backbone of the Hindu tradition all the way up to the colonial period. And so unlike the Chinese and the Mesopotamian rules, but a little bit more similar to the Israelites' rules, these are rules for ordinary people, how to live your lives, how to be good moral people. And it's partly how to perform rituals, what food to eat, about marriage and family and household relations. And there's a set of rules for the kings. So here are the priests telling the kings how to behave. And not only how to behave in their daily lives, but also how to resolve disputes. And so this is where you find what are the most sort of recognizably law-like rules in these Dharma Shastra texts. And they're quite specific, about typical subjects, about injuries, about killing, about theft, about debt, about legal processes. Same thing that Chinese are writing down, and Hammurabi and the Israelites. But these are the priests telling the kings how they've got to mete out justice. And this is part of their dharma, that the dharma relates to the whole sort of the cosmic order that everyone must be conscious of, especially if they have to have a good rebirth. So it's the dharma of the kings to behave as good kings, to mete out justice, and to behave in the right way.
Mm-hmm.
So here you get just another set of laws. Again, these are priestly laws for people, including telling the kings how to behave. And so I think my example, I'm going to go to Rome, but I should just mention Islamic law, clearly a hugely important tradition, which eventually actually grows out of the Israelite tradition. The same thing, and develops into something quite similar to the Hindu tradition as well. Again, it's more of a religious tradition directed to ordinary people, telling ordinary people how to behave particularly. So Rome is interesting because it's a different dynamic yet again. You've had the warlords, we've had the priests, and in Rome, it's the citizens. So it's the citizens seeking justice for themselves. So lawmaking in Rome starts 450 BC, when Rome is still a pretty small town at the mouth of the Tiber. The Romans have got rid of their kings, don't like the kings, so they're now a bit more democratic, but essentially run by an oligarchy who become the patricians. And lots of tension still between the oligarchs and the ordinary people. There's quite a lot of successful warfare. The Romans are going out, they're taking on the Etruscans and others round about. But, as always, it's the ordinary people who are having to be the soldiers, to go out fighting and get killed, get injured, having to leave their lands to other people to farm. So there's lots of discontent on the part of the citizens. And so eventually they create their own assemblies, and they argue that, the oligarchs have got to listen to them and what they want. And they demand laws. And these are the 12 tables, sort of the origin of the Romans' legal system. Very famous. And the 12 tables themselves, insofar as we know what they are pretty basic. They're sort of rules for familiar subjects, injuries and debts and legal procedures and family relations and that sort of thing. But they're written up on bronze tablets, so tradition goes, and put in the forum in the middle of Rome. And it's sort of a little bit odd that the citizens want to do this, because who's going to enforce the laws? They're completely dependent on the magistrates, who are basically part of the government, this oligarchic government. And yet the citizens think it's really important that they should have laws. It's going to help them. It's a sort of statement of, here we are, this is what we want, these are our rights, this is what we ought to get, even if they can't be enforced. So I should probably leave it there and let you take over with some questions. I think what we can see is this, laws being made by very different people. It's rulers, it's priests, it's citizens. Sometimes it's promising justice, sometimes it's posing discipline, sometimes it's telling ordinary people how to behave good moral lives, and the same form, the form of rules can be used for all these different things. And this is even before we got anywhere near the modern world.
Thank you, Fernanda. That was absolutely incredible. Just kind of seeing all these kind of different civilizations and sort of how they came to this essential function for running a complex society in very different ways to each other. The first thing which jumps out at me that I'd like to ask you about is, in terms of methodology, how does one go about sort of studying law on a global scale, and sort of what kind of techniques and methodologies do you need to be able to kind of synthesize all these very different approaches to legal practice together?
Yeah, good question. I mean, I suppose there are two issues here. One is what to look at, and then how to look at it. So, I mean, there's huge debates about, well, what is law? And it's, the legal philosophers go round and round and round in circles debating what law is. But, we all know what law looks like in the modern state. It's made by government, it's administered by judges, it tells us what to do. But what happens when you go to places with very different styles of government or without any government at all? If you start looking at just sort of rules which people live by, ways in which they resolve their disputes, all of a sudden everything becomes law. It's custom, it's tradition, it's conflict resolution. So what I've done sort of in collaboration with other colleagues is sort of think through what's distinctive about law. And it seems to us that something which distinguishes lawmaking and law use from other types of normative behavior is really the use of explicit rules. So hence almost all laws are, in this sense, are written down. Now, if there were oral laws that were repeated, regularly, that might count as law. But once something is written down, on the bronze tablets or Hammurabi's law stone or bits of parchment or palm leaves in India, then it has a sort of life of its own. It has an objective quality. You can read it. Other people can read it. Other people can quote it. It has a sort of power or influence. And that's why laws can be used to constrain rulers. That's why the Brahmins could tell the Indian kings what to do. Here we are, here are our laws, they're in our texts. They've got a sort of objective existence. So that's where I started. So that's why the book largely looks at Asia and not sub-Saharan African countries, for example, left no records from which, well, we can tell very much anyway. So similar thing with most of North and South America. If there were written laws, we don't know about them, largely because most records have been destroyed. So that's a starting point. There's sort of a tradition of writing down laws. Methodologically, in terms of comparison, this is very much a work which I've done on the back of other people's scholarship. So I was going to say most universities, but not most universities anymore. Only a few universities have still got departments of Asian and Middle Eastern studies where they have the real specialists who are poring over this stuff and translating, the archaeologists who are unearthing texts, the people who are working through ancient Chinese documents, deciphering, preserving, and then analysing, working with archaeologists, using a lot of imagination from these ancient societies where, there's very little left in terms of records, trying to, work out what the societies could have looked like, how people could have lived, what the sort of concerns could have been. So all that scholarship is, I've benefited from massively in order to bring out the sort of legal elements and to think about the context in which they were written. So this is very much a sort of contextual approach to law. Who made law? Not just what it said, but who made it and why did they say it and what circumstances, what they were trying to achieve. And then what lives did the laws have when they were copied and transported and gave rise to other things. So it was sort of a work of exploration, really, working through all these different traditions and working out how to tell the story of the world's laws.
I see, amazing stuff. Yeah, I think it's always very impressive when scholars are able to bring together so many different sort of areas and fields and things and kind of draw kind of broader themes out of that. One thing I think that's really fascinating, jumping seamlessly into the subject of themes and kind of patterns in law, is the way that many laws seem to take on a transcendental quality, one might say. So, for example, coming from God, being divine, having a kind of exalted status, even if it's more secular, like say, the nomon, or perhaps even later in history, the US Constitution and things like that. What do you think is the value of kind of prescribing law as having this kind of transcendental quality that's almost sort of handed down and is this kind of exalted thing?
maybe the interesting thing is that even just to go back a stage and to realize that mostly law just seems to take on that quality. So I suppose that's what distinguishes laws from, the rules of a game, for example. We write down what the rules of our game are going to be. We're out there kicking a ball around and we decide what counts as a goal, or we're out there playing cards or something and we decide, what counts as cheating or not. I suppose it's always useful to have something which we've decided upon, so that we know we can refer to it. So we don't have to decide every single time there's a dispute. We don't decide what's right and what. We just say that's the law. It's got some sort of objective quality, and I think it's the same sort of dynamics that are there in these much grander laws. When you've got the kings making laws or the priests making laws, it gives them an objective quality. It's not just us. It's not just us telling you what to do. It's not just us saying we think this is moral and that's not moral. It's God. It's the gods, or in India, it's the Dharma, the sort of the cosmic order of the world, that sort of thing. And ultimately, that's what allows people to appeal to the rule of law. At its most basic, the rule of law is the idea that even the ruler should obey the law. So you mentioned the US Constitution. That's almost become a little bit like a sacred document, hasn't it? I haven't actually seen it, but apparently it's almost like in a shrine somewhere, which people sort of go and pay the respects to. Yeah, and so in a secular context, like the US. It's somehow the document itself, I suppose, gets that, the historicity, the sort of the sanctity in a way, but in a way that's what you need to give a society a bit of sense of stability and a set of values which you can refer to if the people in power are acting badly.
Absolutely. It sort of brings me back to sort of what Machiavelli said about sort of how, the beauty of kind of a divine law that's sort of brought down to you is that it's not sort of devised by people. It's not just a sort of arbitrary rule that, a prince has come up with to sort of lord over their people, but it has that kind of quality of something that's brought down, that kind of binds the people together, that I think, kind of fulfills a lot of those functions without appearing to be, somebody dictating to others.
Exactly. Yeah, it's not me, it's what God said, or it's tradition even. So the early common law, there wasn't that. It's not religious, the early common law. There's no original maker or anything, but it's tradition, ancient tradition. That's for a long time, that's been the sort of the ethos behind the common law.
Absolutely. And I think you even see today in, like, say, English common law, the way that it's kind of built on so many precedents and things that are kind of built up over time, to the point that it almost creates this sort of ancient constitution, as they would say, in the 17th century or something very similar
Absolutely.
to
that. And this was very important in the 17th century, when there's a bit of a standoff between the judiciary and James II, unpopular king, and the judges are standing up to him and saying, you the king cannot disobey the law. Here it is. It was a bit of a standoff, and it wasn't entirely successful, but it can have this sort of really constitutional importance.
Absolutely. I think it's fascinating how that sort of plays out, in many other kind of areas as well. That sort of the law is kind of almost this pillar that can be referred to, to depose a ruler, or even as this kind of a yardstick to measure a ruler against. So the mandate of heaven, for example, springs to mind, or the idea of a shah's charisma in ancient Persia, and the idea of kind of being able to bring that kind of justice. It's fascinating that it has that kind of almost stable quality that can transcend politics or anything like that.
Absolutely. Yeah.
Definitely.
Think of recent examples as well, when Boris Johnson was found to have acted unlawfully by proroguing Parliament. That is the law. The Supreme Court saying, no, sorry, you've got it wrong.
Absolutely, absolutely. And I suppose just sort of following on from that, have you found in your research any examples of where the law kind of gets strained, or where kind of its qualities tend to get sort of challenged or broken down in kind of, political upheavals or anything like that?
Yes, yeah. Let's see. Well, China, every time there was, so Chinese history can be told as a history of a whole lot of dynasties of emperors and rulers, and every so often they're overthrown. Yeah. Oh, excuse me. I might be going to sneeze, or maybe not. And so I think, a stable Chinese dynasty is punctuated by times of upheaval and political disintegration. But interestingly, when a new dynasty established itself, they almost always went back to the laws of the previous dynasty, and basically they produced a new edition, which they said was their laws. And they always claimed they were more just and more lenient than the old ones, but really they were mostly the same. So other things, well, I suppose one of the biggest disruptions in legal traditions has been colonialism. I mean, that's coming on to a very different topic, but a new ruler, a new power coming in with its own very firm ideas of how society should be governed, introducing new sorts of courts, new sorts of laws. Effectively, a lot of the laws I've been talking to are effectively being swept away through the colonial, particularly in India and in China. Whereas in the Islamic world and the Jewish world, they basically hung on to their laws.
Absolutely, and that's, I think quite certainly a tragic in many ways, but a remarkable phenomenon of how, in China and India, you have these law codes that have existed for thousands of years, but then it just gets sort of swept away in the space of a few decades by European colonial powers. And I think it's fascinating as well how, certainly in the Islamic world, Islamic law has kind of become one of several touch points that's used to kind of as a backlash against Western encroachment, Western interference in their sort of countries, and trying to impose something onto them that sort of doesn't feel authentically theirs.
Exactly. I mean, Islamic law is the one of these traditional legal systems which is still very much alive and with us now. And yeah, I suppose partly because it was dispersed very early, very widely. So, in Hindu India, the laws, the Dharma Shastra tradition was largely dominant in what's now India. Largely, although it influenced lawmaking in Thailand, Sri Lanka and Thailand and Myanmar, but they all sort of developed their own traditions. And yeah, I'm going to slightly contradict myself now, I think, because I'm going to say that in China, it wasn't colonialism, because China was never really colonized in the same way as India and most of the rest of Asia, but it was a sort of deliberate attempt at modernity. The last days of the Qing government, the end of the 19th century and early 20th century, there were sort of attempts to modernize, but they were really unsuccessful. And then ultimately it was an internal revolution as the old Qing imperial regime got replaced by the nationalists. And then there was a very determined internal attempt to modernize and get rid of the old laws. So it was different from the colonial encounter in India and places. But the Islamic law, the Islamic tradition had spread so far, right through North Africa, into Spain, into Central Asia, obviously through Turkey, Eastern Europe, and the whole of the Middle East, and a lot of East Africa as well. And because it was a religious tradition, a bit like the Jewish tradition, maybe that's how it sort of when I say it, Islamic law is a lot of different distinct sects and distinct traditions with their own texts and madrasas and traditions of scholarship. There was it has sort of continued really in parallel with post-colonial attempts to modernize. So almost everywhere in Muslim majority countries are now nation states, and most nation states have now got modern style laws. Saudi Arabia, possibly a really interesting exception here. But alongside that, you often find Islamic family courts, Sharia courts, strong Islamic traditions. And there's a huge debate among my scholars who work on the Islamic world about the extent to which Islamic law is really modernized. It's the same thing as it always was. But, there's definitely something there that is much more traditional than anything in India and China.
Absolutely. Yeah. I suppose moving on to another subject, one thing that really fascinates me, just thinking about some of the examples that we've already looked at and maybe some later ones as well, is the distinction that one sometimes gets between a ruler who also prides themselves on being a lawgiver and the sort of societies where you have a separation between those who interpret the law and kind of rulers. So, for example, in the Islamic world, how we have the difference between sultans and, say, muftis and members of the ulama who are kind of debating the law itself. I appreciate what I'm going to ask is a large generalization, but do you find any sort of common themes at all and kind of differences between societies where sort of secular rule and law are kind of intertwined and ones where that's kind of separated out?
Yeah. Well, I think that is a key difference you just identified. And it's largely, I think, associated with religious laws where you have that dynamic between priest and king, essentially. So Hindu India, the Brahmins as the priests and the kings as the kings. And then there's the Islamic world from very early on, that sort of sense of division between priest and king, or between the ulama, the religious scholars, and the caliphs. But then, interestingly, the law was the preserve of the religious specialists, of the ulama, not the caliphs. So it's a little bit counterintuitive there. But I suppose the same as in the Hindu world, it was the Brahmins who were the keepers of the law compared to the kings. They're the ones who told the kings what to do. And the Muslim in the Muslim world is very interesting because the kings were responsible for maintaining order, for meting out justice. So criminal law was largely something they were supposed to be responsible for. The traditional Islamic law doesn't really say very much about crime, actually. It's mostly what the kings, the caliphs, decided to do themselves. And they had their judges, the qadis. But then there were that was sort of on one side, that was the political side. Those are the people who sort of got involved in the dirty business of politics and warfare and that sort of thing. And on the other side, sort of the morally pure or superior side, on one view, were the religious scholars and their madrasas, and they spent their time contemplating, things esoteric and religious and so on. And those are the people who were really the legal experts to whom the qadis were supposed to defer when there was a legal problem. And in practice, you often see them sort of working together. Some photographs of qadis and muftis working, the muftis on the, as it were, the legal scholar side, working together in courts and decide legal cases in North Africa and Afghanistan and places. And I suppose all that contrasts with somewhere like China, where the law was the imperial law, and the law was meted out by government officials, law and politics and political power, all part of that sort of same nexus. And then maybe you could see places like traditions as they developed in Europe, the civil and common law traditions. Maybe those are a different dynamic again, because separation of church and state, obviously the canon law preserved the church, and then the civil law, the preserve of the secular rulers. But there was that division between judges and rulers, which creates that sort of dynamic we were talking about just now with the rule of law, the tension potentially between the judges and the rulers. And on the continent, more the judges and the scholars. The legal scholars are always very important in the continental tradition. And, the rulers on the other side. So they're a sort of a distinct speciality there, although not a religious one.
Yeah, that's fascinating. And I suppose, certainly in the Islamic tradition, what I find sort of really fascinating is you have this kind of separation. But in many ways, you have the Sultan, for example, sort of looking over justice, having victory in war, and then the ulama kind of, interpreting the right way to follow God's will. And it's almost as if it's taking those kind of two things that kind of the old Mesopotamian warlords were promising, but putting them into different spheres. And I think that's fascinating, that even though it's a very different way to sort of practice the law, the aims sort of almost come back to themselves like that.
Yeah, absolutely. The aims are still to work out the best way of doing things, to create rules, guidance, and mete out justice ultimately. But yes, very different ways, as you say, of achieving those aims of different people.
Absolutely, definitely. Now moving on to medieval Europe, I think one thing that I find fascinating, and I think certainly for many people can be quite challenging to wrap their head around, is the way that you have sort of so many different kind of courts and legal systems kind of all coexisting together. So I think, for example, in England, we have things like the Admiralty law and the law of kind of tin miners and things like that existing, as something in and of themselves, but also kind of in this framework of kind of common and civil and then canon law on top of that. And I can imagine, for kind of a lay person, imagining that in a society where law is very standardized and centralized, that's quite tricky to conceive. I mean, out of curiosity, how would that kind of work in practice? And why was it sort of, was it a good thing to have all these kind of different separated spheres of law?
Yeah, absolutely. You're right that now we think of there being a single legal system. Every state has got to have its laws. And even if the state system recognizes certain local laws or forms of justice, there's a single legal system and there's a single answer to everything. If you need to, you can go to court and you go up the pyramid till you get to the Supreme Court at the top. And that's really the model which has now taken over the whole world. Every nation state is meant to have its legal system. So to the extent that, in the West, we recognize sort of spaces for religious laws, they're very much sort of carved out, and it's the national legal system that recognizes to some extent the decisions of a sort of religious tribunal. And so exactly it in the Middle Ages, when there was this multiplicity of laws, it's just completely different sort of way of thinking about the legal landscape. And I mean, it's difficult to tell whether that was just chaotic or was really very pragmatic. And my suspicion is that mostly it probably worked quite well. That if you had, if you lived in a manor in England, and there was the manorial court which sorted out most sorts of things. I mean, maybe not very well, or maybe it was more or less just, but that's where you went to sort out your dispute with your neighbors, or how much taxes you are having to pay, or if there was somebody trespassing, you would get the lord of the manor to deal with it, you hoped. So there was that. And then, but if there was family problems, you went to the church, and the priest would deal with those sorts of things, and also with things like slander and insults. They're quite involved in those sorts of things. Those are wonderful examples of the sorts of sort of language they had to adjudicate on from manorial roles from the 15th, 16th centuries. These are really important.
Yeah.
You're a merchant, your local fair, there was a court there to deal with the disputes between merchants. Of course, that was quite useful because the people sitting in judgment there would probably merchants themselves. They understood the problems you're having with credit or debt or substandard goods, all that sort of thing. And as you said, if you're a tin miner, there was a whole lot of special courts to deal with tin miners' problems down in Cornwall. And if you're a fisherman, there were There were admiralty courts to deal with the fish. I mean, it probably was quite pragmatic that the people in those local areas who made up the juries, they followed similar forms. They would often get a jury to decide questions of fact. And the people who made up the juries probably sort of understood the problems that were likely to arise in those contexts. But there's definitely evidence of, disgruntled people not liking a decision of one court and going off to try another court, and cases dragging on. But you might just think, plus ça change, justice has always tended to drag out, especially if people wanted to drag out.
Absolutely.
Yeah.
Yeah, I suppose it'd be fascinating to kind of see in practice how that would sort of work. Because certainly sort of drawing from my own kind of background in the Islamic world, it's fascinating to see how, for example, people going to Christian or Jewish courts may not be happy with the ruling. They might go to, say, an Islamic court and, have that kind of ability to be able to choose between which law court is kind of arbitrating their decision. And I think that's fascinating. In the sense that, nowadays we'd assume that, once a court kind of makes a decision, it's absolute, that's that, unless you appeal further up the chain. But it's fascinating that kind of, back in this period, if there's something you wanted to dispute, you'd still have other avenues available to you to be able to challenge that.
That may not have been such a good thing, obviously, because if you're dragged into a dispute and you want a decision, the last thing you want then is the other person on the other side say, okay, we don't like that one, we're going off and again, and when's this case going to ever end? So, I suspect those sorts of issues came up quite a lot. There are arguments about whether another court ought to hear a dispute or not.
Oh, absolutely. Absolutely. I'd dread to be, perhaps, say, a magistrate somewhere who had to deal with, the umpteenth time something's been brought forward after going through lots of different kinds of courts and things like that. Absolutely.
Yeah, I've got a nice example. Well, it's sort of nice example in my book about a dispute from the Atlas Mountains, north, I think it must be what's now Morocco, between two villages, and there was a single stream, and there was a village further up and a village further down. Everything was fine except years of drought. And then the village at the top took all the water, and the village at the bottom complained they didn't have enough water. And this dispute between them got litigated over more than 100 years. They would go off to an Islamic court and they would get sorted out, and then the problem would happen, 10, 15 years later, and they'd go back to court, and then the Qadi would go to a different mufti and get a different opinion. And so it was sort of good that they could keep going back to court, but sort of not good. You thought they really would have liked a decision.
Absolutely. I imagine they're probably very relieved when they sort of finally said, right, that's this, and that's how we're going to decide it from now on. Oh, goodness me. And of course, we've been talking quite a lot about sort of the written laws, and I think we mentioned earlier, that's kind of what separates it from, say, just kind of customs and traditions and things like that. But I'm curious, just maybe going off on a bit of a tangent here. How do perhaps, say, societies where they don't write down laws regularly tend to compare? Like, say, for example, those folks in Ladakh.
Sorry, which example do you say?
Oh, right, sorry. For example, the folks in Tibet who sort of didn't write down laws very regularly.
Yeah. Well, there's probably lots of different dynamics here. In smallish societies or networks, customary rules can be well entrenched and everyone knows what to do. So the village in Tibet where I did my field work, they would talk about their customs in quite explicit ways. There's things like inheritance, which are quite complicated sometimes, and there could be disputes about it. They had very clear rules. We do this, we don't do that. So if the community is small enough, you can have oral rules which work in more or less the same way. So I suppose in Eastern Tibet, even though they had these written codes, mostly they would just mediate their disputes. So it was more a sense of the process. If there's arises between us, we go to mediators. This is what they do. Again, they've clearly underlying principles that everyone accepted. But in larger societies, autocratic rulers love not having laws. ancient Egypt, very sophisticated, centralized society, centralization of wealth, taxation, no obvious lawmaking. And I suspect there was a lot of local government, and that many of the pharaohs were just rather autocratic about, and maybe quite whimsical about how they meted out their government. Another good example, mafia. Now, people talk about mafia laws, the code of honor and that sort of thing, but it's pretty thin. From what I've read, there's not a lot of really explicit law, and avoiding writing down laws gives the opportunity to the really powerful to just get their way. It's the sort of thing that was illustrated in The Godfather, that we've all listened to. If you're powerful enough, you can do what you want. And of course, if you're a criminal organization as well, you don't want to be seen by the authorities. So the less you write down, the more you can be unseen, unobserved, escape, the authorities, and also take advantage of a powerful position.
Definitely.
So yeah, there are good and bad reasons for not writing down laws.
Quite right, because I can imagine, when you don't have, I think, as we mentioned before, that kind of sort of guide to refer to, which kind of takes on this kind of transcendental quality. Would I be right in saying that sort of that power kind of ends up in sort of whoever happens to be kind of in charge and whoever happens to be the most powerful person in the room at the time?
Well, exactly. So in some traditional societies, they've got other ways of controlling power. So they maybe rotate principles, positions of power. That's quite common, actually. Or even use dice or that sort of thing to decide who gets position of power. Particularly sort of small scale village communities often works like that. But yeah, when things get more centralized, more hierarchical, absolutely, it's whoever has power, unconstrained by the law. That's why we think the rule of law is so important. At least if there's some rules, then it's easier for other people to say, hang on, you've broken the law here. It doesn't by no means always a guarantee that it's going to be a check on power, but at least it gives us sort of a set of arguments to those who want to stand up to abuses of power.
It sort of gives them that framework to challenge, a powerful individual who's just kind of throwing their weight around.
Exactly.
Absolutely.
Maybe that's why, in the present day, quoting international law in the Russia-Ukraine conflict or, the Israel-Gaza conflict is going to make no difference at all. Nevertheless, it sort of feels important that there are laws which can be quoted, which at least provide some theoretical framework for thinking about what's going on.
Definitely. And I suppose it at least sort of helps us to understand, kind of line in the sand, what's okay and what isn't.
Exactly.
Probably more the latter in the case of the two examples. Absolutely. And I suppose it's unfortunate we're coming near to the end of our time. Just to sort of round off, I'd like to ask, where are the current blind spots in sort of anthropology and law, and where would you like sort of studies in this field to go next?
Well, I think there's lots that can be done with historical material. Anthropology and history, they've always sort of had a sort of positive relationship, but they were sort of kept to their own devices, really. But I think comparing often contemporary societies with historical societies is particularly fruitful. And given that we often have legal historical records, but very often some of the earliest records people make are legal records, there's a mass of material that can be used in sort of fruitful conversations between anthropologists and historians.
Absolutely. And are there any kind of fields or themes or things that you'd like to potentially explore next in your research?
Well, I'm probably going to do a bit more work on Tibet, but look at historic law in Tibet. It's interesting because it was a very sophisticated, literate society, and dominated by Buddhism and ascetic Buddhism from about the 7th century onwards, yet very, very little lawmaking. So that raises a whole new set of questions, really. Why do some sophisticated societies not make law? How else do they see they ought to regulate themselves, regulate the people? So that's something I want to look a bit more closely at. Having done this big synthetic book, I want to go back to the coalface in a way.
Absolutely.
Legal texts.
Definitely. Sounds fantastic. Well, unfortunately, we've come to the end of our time today. Pity to us, I think there's so many kind of other rabbit holes we could have dived into and so many other topics we could have covered, but I'm afraid we're going to have to end it here for now. Fernanda, thank you so much for joining us this evening. It's been a pleasure to have you. Thank you very much for everybody watching, and we hope to see you in the next episode. Take care.
Thank you for the invitation. It's been a pleasure.
Thank you. Goodbye.